I'm Rochelle Wilhite, the designated broker of Best Choice Realty. I have had a pretty good day today. I started my day off this morning with speaking with an attorney, so I'm ready to rock and roll here this evening. Talk about the top 5 legal issues for real estate agents. Again, this is current, and you'll notice there are some common themes. And I think what's happening is people are starting to form complaints because the market's starting to adjust. And when that happens, we want to be well-versed, especially at Best Choice Realty, about what things to kind of watch out for. We don't want to make the same mistake as some of our colleagues out there in the industry. So I'll be sharing a few experiences and a few examples with you tonight. And again, this is recorded. So if you have questions or if you just want to speak up, if you want to just send us a message in the chat, that would be great. And at the end of the session, I'll have Shannon go ahead and read some of the questions if they're appropriate so that we can handle those. Or if you have a question outside of this meeting, if you wanted to send me a quick note, you can email me at rochelle@bestchoicerealtywa.com. I'm happy to respond that way as well. So let's go ahead and get started, Jan. Let's go right into it. Top 5 legal issues, starting off with number 1. There is a lot of problems, and I guess this is going to really start our conversation for especially the new forms that are coming out here in October. But I find that it's very interesting that the state of Washington is going to have to step into it. As much as we have not used the buyer agency agreement in the past, my understanding is we're going to see a lot more conflict and legal issues surrounded around using or the lack of utilization of the buyer agency agreement. So I wanted to kind of briefly go over a few of these points on the screen here. What I find most interesting is in the last year or two, ever since the MLS has changed the forms to make it more transparent and to have that conversation, the listings have to have the commission amount of who's paying the buyer's agent, what that amount would be. We knew it was going to come, but we're having much more debate around, is there an agency agreement established and when to use it? Most people are finding that they're a little some people use it all the time, and that's great. We've been training new agents that enter the industry to go ahead and use the buyer agency agreement. But some of the old dogs, me included, where we did not have to use the buyer agency agreement, what we're finding is that there are some brokerage firms that are really not playing nice in the sandbox. And what they're doing is stealing your client from you. And you may not realize it, but if you had established agency, there is much more of a legal path to journey down if you were to find that your buyer ended up going with another broker. So there are currently, I have 2 complaints that I'm working on right now with our local MLS that have to do with the buyer agency agreement or the lack thereof. And it's interesting to realize where these kind of things come from. So I think the question that many brokers ask me is, when do I use a buyer agency agreement? In other states, it's a requirement to use the buyer agency agreement, where in Washington state, it's always kind of been this uneasy, uncomfortable kind of agreement that lacks kind of teeth in it, if you will, to actually enforce. But I think when you start to see these agreements come out in October, I think it will be very beneficial for you to utilize a buyer agency agreement so that you can establish how you earn your commission, what is commission, how do I work with you as a buyer's agent. It really kind of sets you apart and sets the tone really for the start of your transaction or how you earn your buyer agent commission. So really, when should you use it? I would say start, if you have not, start using it really when you start to work with a buyer. The moment you sit down and do a consultation with them or you go out on the first appointment, that's when I would use a buyer agency agreement and just make it a firm requirement. Just say my brokerage firm requires that we start to use this form that establishes what I will and the scope of my services and how I get paid. If there is any agreement between you and say your family member or somebody that you're transacting with, maybe it's a friend or family member, you've agreed to give them part of your commission. Again, that has to be approved by the brokerage firm, but I will go ahead and on a case-by-case scenario, go over that with you. So it also begs the question is, if you're going to be doing some sort of credits or kind of sharing of commission that way, that would be the appropriate time to have that conversation before you start writing a contract. not after the contract is written. It really should be done before you write a contract at a minimum. Is the 40, before I said, so some people ask me, well, I've never used a buyer agency agreement. I just give them the disclosures, and I would think that that establishes agency. It actually does not. Agency is established when you do a contract, when you write a purchase and sale agreement. There is agency duties that are started at that point in time, but you can often get your agency agreement to start earlier if you do establish agency with a buyer agency agreement. So some people say, well, I've given disclosures. Isn't that the same? It is not. It is just the rules that we have to follow by law in Washington. We have to give the agency pamphlet specifically, and then confirm that we have sent that to them, but that does not establish agency. An agency agreement would do that. Is the 41A, that's again one of the Northwest MLS approved addenda or contracts that's listed there. You can locate that on the Northwest MLS. Not everybody is part of the Northwest MLS. So would a Best Choice Realty agency agreement essentially be the same? And the answer is you use one or the other. The Best Choice Realty agency agreement will get modified in the coming, probably in the fall. But when you compare the two forms, there's a bit more to the buyer agency agreement when it comes to using Best Choice Realty. And there is a path for how we go about using our attorney on staff to essentially try to go after that buyer and have them pay that buyer agent commission. It is something separate, and sometimes when we have to go after commission in that way, it's easier to use the approved legal Best Choice Realty agency agreement than to use the 41A. If we are using the 41A, we can attempt to collect commission by going through the Northwest MLS arbitration committee, and that often is seen very well when it's going up and against hearings. To not use a buyer agency agreement, then what they're looking for at the Northwest MLS would be several instances where who was the procuring cause of the sale? What work was done that particular client? If there was no buyer agency agreement, could there be a case made that, say, somebody that showed the house at an open house and worked through all the questions and got the financing all lined up? There could be a case made without a buyer agency agreement that there was commission earned without using the appropriate form. So as far as that goes, I would say just get in the habit of trying to introduce that if you have not used a buyer agency agreement, and it will solve a lot of the problems of disputes that come for, hey, we've been working with this client for X, Y, and Z, or for X amount of time. Am I owed a commission if somebody steals my client? And if there is a buyer agency agreement that's been put in place by that other broker and you didn't put a buyer agency agreement in place, there could be claims made that you don't earn the commission that is earned by whoever established the agency agreement at that time. Some courtesy at open houses. I get this question asked a lot, and there are some complaints that I've been involved with and have observed from other brokerages from the sidelines. And I can tell you that there needs to be some courtesy at open houses and an understanding in the general public. When you're doing an open house, who do you represent? Do you represent the seller or do you represent the buyer? And if you are representing, make it very clear when people are coming through, if they are interested in the property, that you do, if you are the listing agent, you do have a duty to represent the seller. And in the case where, say, a buyer is interested in writing an offer on, say, that open house, and you represent the seller, it is a requirement. It's not something you can choose to do. You must have a buyer agency agreement when you are representing a buyer and they become interested in a property that you have listed. It's not that you can represent both parties. In order to have a dual agency, you have to have a buyer agency agreement signed and established with that buyer before you introduce them to the seller. That's how you can properly represent both parties. If the seller said to me, Rochelle, I don't want you representing the buyer, I would have to find somebody else to refer that buyer to, so that the seller could be properly represented and the buyer could be properly represented. I cannot represent both parties if the seller elects not to have me represent both parties. So that is something that's outlined in the law of agency pamphlet. And many of you do not realize that you have to establish agency That's another example of when you would use a buyer agency agreement or a 41A, and that is a requirement, is when you represent both parties. So in the instance of an open house where you're representing the seller, let's say I have a listing and I'm going to do my own open house, not have somebody else in the firm. If somebody else in the firm represented, the property and was actually sitting at the open house and I was not there, essentially that buyer's agent or that agent that works for Best Choice Realty would not be a dual agent, but that agent would be representing the firm and would be a buyer agent. So if a buyer had come through the open house and had expressed interest, you also may want to go ahead and put a buyer agency agreement in place at the open house. So if you are representing, a buyer in that instance, you might want to have one printed so that you can go ahead and establish agency right then and there on the spot. There have been cases where, there's a discrepancy, you're stealing my client. I hear that quite a bit because you're open house. Are we allowing for that? We really should be asking questions when people are touring the open houses. Have you signed an agency agreement with that buyer? If the answer is no, then you can continue to work with that buyer and give them information if you truly are a buyer's agent and you're not a listing agent acting as a dual. So there's got to be some courtesy at open houses, especially when there are people letting their buyers tour through. But I can tell you right now, I'm well trained to ask questions. And if they have not signed a buyer agency agreement, then I am going to continue working them and helping them find the best property for them. Because if I'm going to sit an open house and essentially get clients to, work with me, because I'm looking for, if I can't sell this house to them that I'm sitting, let's sell them something else in the other, neighboring area. I probably want to establish agency, but I also want to have common courtesy and ask the question, are you currently working with another agent, or have you signed a buyer agency agreement with that other agent? If they have, let them tour the property and have that common decency of just calling that other agent and just say, hey, Kelly, thanks so much for sending your buyer to my open house. It went really well. They were very interested. You may want to follow up with them, but I recognize that you have an agency agreement with them, and we highly encourage that type of cooperative behavior at Best Choice Realty. We definitely want to have that type of kind of back and forth, especially when they have established agency with that client. We don't want to be seen as Best Choice Realty stealing people's clients. That's not what we're all about. So there needs to be some courtesy at open houses, ask the right questions, work with that other agent. If they've said that I'm working with X and that person, you talk to that person, and they have a business card, and you can definitely say that they, are working with that agent. Don't steal their client. Just go ahead and give them a call and see how you can best work and put an offer together. Let's go to the next slide, Shannon.
Yeah, before we do, we had a question that was asking about what if a buyer doesn't want to work with a certain real estate agent anymore? I'm assuming that how do we terminate basically an existing buyer agency agreement?
The buyer agency agreement is with the designated brokerage or the firm and the buyer. So if there was, you just like listings, you cannot solicit that buyer agency. That again would be a violation of the Realtor Association Code of Ethics. So you can't solicit that buyer away from that buyer agency agreement. But it's that if you're wanting to know what the law is, that buyer would have to cancel that agency agreement with the designated broker or managing broker of that respective firm in order for that buyer agency agreement to be null and void. So it would require written confirmation that I would see. Let's say somebody came to me and said, Rochelle, I don't like my buyer agent. I can't tell you, Shannon, that you can get out of that deal or give you a path of how to do that. I would say, you know what, you really should talk to the managing or designated broker of that respective firm and confirm, see if they can make it right for you. And if that doesn't work, once you're out of the agency agreement, I'm happy to work with you, but I cannot step on anybody's toes. That's what I would say if I was in that certain circumstance. Does that make sense?
Mm-hmm.
Okay. All right, showing instructions. That is huge right now. I have already got 2 complaints that have been filed against Best Choice Realty from this weekend. So I have to deal with them. I have to handle them. Please help me help you so that I don't have to write up these long responses and defend you guys in these showing instruction complaints. Some of these can be clearly avoided if we follow these simple rules that are up on the screen. I'm going to go through them. It doesn't matter if you are working in Yakima, Spokane, or on the west side. These are all common courtesy things that you really should do if you're going to practice real estate and practice it well. So if it's not a rule that your MLS, abides by, again, this would be best practice and just kind of the rules of conduct that we all adhere to at Best Choice Realty. So if you do cancel your showing appointment, if you would please do that. If your buyers change plans, do yourself a favor. Sellers get really unglued, especially when they have kept their house up and they put the dishes in the dishwasher, they've made their beds. If you had made an appointment and then you don't cancel and let that listing agent know, it's super important just to kind of set the tone early for a good reputation. So if you do have to cancel, make sure you give the listing agent a call and let them know that you apologize and let them know that the buyers just changed their plans, and as much notice as you can possibly give that seller, the better it is going to be to kind of set the stage of your professional standards. There is a rule 11G, always review and adhere to the showing instructions in the listing before you go to the property. That means you're using the Home Spotter app, you're using the Home Stamp. I know there's all these different apps and we're moving a bit swiftly now that there's more inventory that's appearing on the marketplace, but that does not negate the fact that you have to look at those agent-only remarks and their showing instructions. So if there's an appointment required, or if there are rules around COVID, or if accessing the property at a certain time frame, or following instructions, even if you're on your phone, I find it interesting that more complaints are being filed on Rule 11G than we ever have since, I think, probably 2016. And it's just simply can be done by just looking at your phone and making that just quick check before you actually use your key box. It does not take long. I don't like excuses. We're actually having to do some long write-ups in terms of trying to make sure that our agents are not fined, but the fines can be steep. And it just can be solved very simply by following the rules that you just looking at the agent remarks and making those adjustments. So slow down, I would say, when it comes to Rule 11G, and make sure that you're actually adhering to the showing remarks. There's a reason why listing agents will put those showing remarks in. And a lot of it has to do with sellers' health and safety. There are some areas of crime that are, that make sure that it's for your safety as well as for the other agents or for the seller or the buyer's safety as well. So make sure you're going ahead and following those showing instructions. I realize some sellers are super petty, and I do realize that buyer's agents are now touring more people through a lot more homes than we have in the past, but still, please help me help you in following Rule 11G. Rule 50A, always logging into the key box and returning the key promptly. This is also a quick reminder for those of you who are listing agents. Definitely make yourself a duplicate key when you take a listing, because there have been instances where we've lost some very valuable showing time. I'm gonna have to shut my door here. 1 second, Shannon, go ahead. Hold on a sec. There we go. So we lose some valuable showing time if somehow the key doesn't get placed back into the key box. So we want to make sure that when you show the property, you properly return it to the key box. Now we're getting some overlap on showings. So if there is somebody else, make sure you pop it back in the key box, and then let that next person use their key to activate the key box as well. And you cannot give your key to anybody. That means your phone. So if you're like, oh, I'm not feeling good, I'm sick, you can't give it to your husband to go show the property for you, or you can't give it to another real estate agent to show it for you. You have to use your key that's in your possession, and unfortunately, there's no way around. A lot of times I can help you with 11G if it's your first offense, but 50A, that's a very serious offense when you're not using the key and returning it promptly to the key box, because we lose incredible valuable marketing time. Also, the security of the property, making sure all the windows and doors basically leave the home in the way that you found it. 50A, never leave a person, including clients, inspectors, contractors, etc., in the property unless you're there with them. We don't want to be blamed for something that a contractor would do or an inspector would do. So definitely watch 50A. I think that's one of the top rules that I see fines associated with, and it's very hard to get somebody, to debate the fact that we left the property unattended or that we did not put the key properly back in the box. I know this is a struggle. This has always kind of left me uneasy as like, oh my gosh, do we have to leave a business card? But 180A, for a period of time, for a couple years, in fact, we did not have to leave a business card, but now we have, it is a rule, at least on Northwest MLS, that we must leave a business card after showing the property. So that rule 180A, although it was off for a while because of COVID, it's back in play and you must leave a business card. So if you need some more business cards, we do have some here in our office, some burner cards if you need some, or if you'd like to get with our marketing department, they can order you up some new cards. But rule 180A is back. Let's go to the next slide. Showing instructions. So the other thing that I'm seeing a lot of problems with legally, and this is another one that I'm working with, and I've had to settle something out recently, would be having to do with a listing agreement and how a listing agreement is taken and what is put in the listing agreement. And this, just like a purchase and sale agreement, it's a super important contract that has to be filled out correctly. Otherwise, you run the risk that you may have not earned your commission, or you may have a listing and you may personally be sued, or your clients may be sued, or you can have some legal implications that would occur if you're not doing this correctly. So I'm going to give you kind of the high level, and it has to do with the vesting on how the listing is, how the sellers are vested. I think many of you are getting that phone call and you're just like, ooh, I'm so excited, I got my first listing, or I'm just so happy to even have a listing because it's been a while since you actually had a listing. But don't run into this speed block or this kind of speed block right here. And you're going again too fast and not slowing down. Always, always, always order preliminary title before you take a listing. And then what you're looking for to make sure that you have the name spelled correctly on your listing agreement is the vesting. How is the client vested? How do they spell their names? Are there middle initials? Are there last names? Is there something very specific that has to be on that listing contract? So quite simply, I had Shannon pull this one up because this is one of our listings that we have. Dallas and Cleo both passed away this year. In fact, I think Dallas passed away in January and Cleo passed away in May. And so now the trust is actually selling the listing. So we ordered preliminary title. Now, if we ordered preliminary title when Cleo was still alive, it might look differently than the way it looks right now. But the commitment date and the vesting is Dallas R. Britt and Cleo Bell Britt, joint trustees of the Britt Family Trust. So that's what I would put on the listing agreement, but the signer would be whoever is, because both have passed away, it would be the trustee of the Britt Family Trust. That would be who we would need to have sign the listing agreement. But the listing agreement needs to be filled out correctly with the name spelled correctly as well. If there is something such as a trust, an estate, or you find out that the vesting is like, maybe it's a married person, maybe it's not, and you kind of are not feeling so sure of yourself, or you feel an uneasy feeling, you may want to ask, and certainly you're right, you're the person that's out there representing Best Choice Realty and representing my license. It certainly is okay for you to ask more questions or to have the seller provide some sort of documentation showing that they are the signer for the trust, or that they are the one that's eligible to sign for the divorce, or eligible to sign on behalf, or that there's a power of attorney that's properly established for signing, say, a husband and wife are estranged. We want to make sure that we have the proof that we need to make sure that we've taken a valid listing. Once we have looked at the title report and had that conversation with our seller, only then can we properly make sure that we have our listing agreement filled out. So it really starts from the point of listing. What could potentially happen is you go down and you get a buyer, and the buyer ends up purchasing, and then the seller refuses to sign because there's a dispute on whether you have a valid listing agreement. then we have a problem that can be avoided by just making some certain checks and balances. If you ever have a question about, can this person sign, or can we check with title, it would be better to have that addressed before we sign the listing agreement, but even better before we get a buyer that ends up wanting to purchase it. So that seller line needs to be filled out properly. The address needs to be filled out properly. It is not a valid listing agreement if you do not have the listing date in that section on line 20. There is not a default, so that would beg to say that you don't have a valid listing agreement. We technically could take the listing from some other firm if they did not have the listing date on term 3. Please do not make that mistake. We made that mistake about 6 years ago, and it cost us. John L. Scott actually ended up getting that listing, and our poor little rookie agent did not get the listing because he failed to put in the number 3 on the listing date. Commission also should be the total commission. Most buyers and consumers do not understand. Certainly sellers, if they're selling for the first time, do not know what the total commission. They seem to think that term 4 means they're paying 6% plus an additional 3% if you have 6 and 3 on that section of term 4. So make sure you have advised the seller what the commission is and what happens in these certain circumstances, and you kind of explain to them what term 4 means. If you go to the next page, Shannon, the last page of the agreement, I often wonder, why do we have this section where on line 115 where it says, are the undersigned the sole owners? And I often ask that to attorneys that I run into, and they often say it's the way of just checking off that you have done your due diligence. You verified with the seller that the title you ordered and the listing agreement you have in front of you, that they are truly the undersigned owners, and they've signed on their spot there that they have the right to sell. And it matches the vesting, and it matches the last vesting deed, and we have a valid listing agreement. So there's kind of a nice checkbox just to remind yourself. I don't think anybody's checked the box no, but when you do check that box, or when the seller does sign below that, are the undersigned the sole owners, that does put ownership on that seller, that also means that they have the right to sell the property and that they are the sole owners. And then you sign obviously on 117. Let's go to the next one. So I see a lot of that. I also still see a lot of earnest money disputes. A lot of my day is taken up with handling earnest money disputes. I have a few of those. I get probably 5 to 7 earnest money disputes a month with the amount of transactions that we do. I personally take those seriously because they have a lot to do with the contract. So here are the top 4 earnest money disputes that we're handling. We just had one that we worked on today. I got news from the agent that we were able to get that resolved, but it actually was a managing broker that made the mistake. He ended up sending the entire inspection report. When he sent over the 35R, he also delivered the full inspection report. And if you look at Form 35, he waived the inspection for his buyers. But then he got pretty upset about that, making that mistake, and tried to blame it on our listing agent. But that is a potential earnest money dispute that would have happened if he would have terminated the contract without legal recourse. He does not have that right. The only way he would be able to terminate the contract would be on finance. And potentially some of the items that came up on the inspection report that he was asking for would have come up where he may not have been able to get a loan. But that took a little bit of navigation between the agent and I, working through that situation and coming to an agreement, some good win-win conversation and negotiation between both the buyer and the seller. So be careful on your inspection reports that you're not delivering. There was changes a few years made to Form 35 that would make your inspection waived. And then we have to work on earnest money disputes that would happen after that, which also reminds me that when you have a 35R and you have asked for an inspection, that's a pretty clean, easy way to exit a contract and get your earnest money returned to you. Past the inspection contingency, it becomes a bit more complicated. In fact, a lot more complicated when it comes to earnest money disputes. And we have to make sure that the parties have proper, like for example, financing, failure of financing. Even though you send over the proper notification to exit the contract and demand the earnest money, there still can be an earnest money dispute that's had between the buyer and the seller when it comes to, did you do a good faith effort in your financing? Was the denial based on the financing 22A, or was it truly the buyer's problem or the seller's? So there is a lot of disputes that happen around finance failures, especially now. There is also disputes that I've handled when it comes to the parties, one or the other did not sign their paperwork before the closing date. And then there becomes an earnest money dispute. And we have to look at the financing contingency or the lack or the earnest money non-refundable clause that kind of comes into play at that point. We need to watch our timelines on earnest money disputes, especially when it comes to earnest money non-refundable clauses, but not signing paperwork or buyer or seller not signing paperwork. Please involve me earlier in those disputes before you pass the closing date, because then the earnest money disputes do become my responsibility to handle that. And sometimes it's in your favor, other times it's not. And we don't want to lose our earnest money for our buyers or sellers if we can avoid it. There are some seller performance where sellers have just changed their mind about selling, and those earnest money disputes have legal complications. And certainly I want to be aware of those if you have situations like that. Next, the last slide, I think, Shannon, comes to the earnest money non-refundable. We still, even with our marketplace kind of easing for buyers, we are still having issues with non-refundable earnest money. I still am seeing you guys or listings where you are accepting that type of language. It just clearly says the earnest money is non-refundable. We do want to make sure that the buyer's agent is writing that appropriately, because it does implicate our sellers, and especially when we're in the middle of a contract and we have an issue with earnest money or it becomes non-refundable, that language must be attorney approved language. I want you guys to use that form 34 in the transaction desk that's been approved by our attorney. That is the best type of language to use. But just keep in mind that anything above 5%, say the 5% of the purchase price, it cannot be collected by the seller. So there should be some discussion if you represent the seller about that earnest money amount that turns into a non-refundable deposit. And the seller should be notified that they really should not be using that money if it's dispersed early from escrow. They should really kind of wait that out because of the way the Washington state contract is drafted. There are earnest money provisions that are more in the interest of the buyer rather than the seller. Although I can understand a seller's perspective of wanting that earnest money released to them early to just give them confidence and knowledge that they know that this contract would likely go through. So we're still seeing a lot of these non-refundable earnest money, but actually less of it, and hopefully less of it in the future as the market starts to adjust. I think that is pretty much it. Yeah, that's great. And it's 6:03. I tend to talk really fast, as you guys know, but certainly willing to take any questions that you have at this time. Shannon, go ahead.
I think we had a question about the difference when it comes to commission between the BCR buyer agency agreement and the 41A. Okay.
Let's go ahead and just pull that up real quick. There is a way to find that. You can go to bestchoicerealtyhomes.com. That's where you would find the BCR buyer agency agreement. So I'll have Shannon go ahead and show you guys what that is and where you can go to find it. And I'll show you a couple things on that BCR buyer agency agreement. It's different. So you would go to members. It is in our member resources and it is in our downloads. And then if you go over here to the real estate forms, you can pull it up right from there. We call it BCR Form 41A. You really are just dragging and dropping the buyer's name, and it goes into that top section. But the scope of services, it does allow for a bit longer, I believe. Let's scroll down, Shannon. So other provisions right there, you could put in other provisions where you're maybe offering some sort of credit. That would be in section 1. So there's some more room on number 1. You can do something there. Number 4, there is a retainer fee that is actually not part of the 41A. Some of us in outlying areas, maybe we're driving a couple hours. We may throw a retainer fee in there just to cover our gas. We use this a lot. Actually, when the gas was up before 2008, we used a retainer fee. That was great to use, especially when we're showing, some smaller property types where we know we're only gonna get paid X amount of commission. Sometimes it makes sense to go ahead and put a retainer fee, and the buyer's fine with paying it because they know they have representation and they know I'm gonna be driving out to Long Beach, for example. I've used Section 4 a lot, and the retainer fee that's part of our buyer agency agreement because of that. And then B has a 3% if not filled in, so it's already agreed upon. And it does provide kind of an instance that we actually try to get the additional commission paid for by the seller if it's not paid. And if we do, that we are only paid whatever is agreed upon. So it's pursuant to paragraph 4. So there's a bit more language in term 4 that is not part of 41A that I like a lot better. If you go to the next page, dual agency, I believe, is covered. I don't believe that is covered in 41A, but I have to check. But in mortgage disclosure, that is not part of the buyer agency on 41A in the Northwest MLS. And we do have a lot of people who are part of loan originators or doing loans. There is a checkbox that they can use so they can establish themselves as a loan originator as well as a buyer agent. There is a way to do that, and they can use our buyer agency agreement. And I believe non-discrimination is part of 41A. There are just some slight differences. You'll notice you can compare this to the 41A on Northwest MLS, but I would say that the scope of services is different and Section 4 is different in terms of the differences between the 41A the Northwest MLS provides versus the Best Choice Realty. Okay. Shannon, hopefully that answered the question there. Anything else, Shannon?
No, I think that's good. I know one of the things that we had on the slides was about making sure that you've logged your key and you leave a business card. I think we're seeing this a lot recently where we have more listings that are on the market, and a lot of the listings that are coming up on the market are actually owner occupied. Yeah. So think of it that there's twice as many, 3 times as many owner occupied properties that you're showing. And it's doubly important to make sure that you're leaving a business card so that if something happens, they can go to, oh, okay, so this person was in my house. I can call them. Yes. Or, the gate was left open. We can figure out very quickly who that is. And I think it ties in with your cancellations. So if you're showing properties, it's important to cancel it because the listing agent, if you have a showing that's scheduled in that time where something may have occurred, they're going to call you first and say, why didn't you show up? Did you show up? What happened? Mm-hmm. Something happened at the house at this time. So if you're showing homes, just make sure if something changed, cancel it, but also leave a business card so that that seller knows who's coming through their house. I know for me, my buyers' clients always laugh at me because I always knock on all the doors whenever I enter them because you never know. They could still be in the house. So, yeah.
That's a good point. Any other comments? I appreciate your insight on that, Shannon, about, yes, there are probably a lot more owner occupant homes on the market, and they come with a mixed bag. I think the one complaint I'm dealing with right now is like, wow, I mean, super, they've even taken the key box off. They're so spooked by the whole process because our agent did not properly follow the showing instructions that it's impacting the cooperative broker on the other side to be able to really work with that seller. So that's where it becomes really kind of a sticky situation where I don't know if I'm going to be able to get our agent off the hook on this one because they are losing that relationship with that potential seller. I know the designated broker well, and he knows Best Choice Realty well, and that we take it very serious on some of these things. But there's something to be said about sellers living in their property and somebody's coming into their space, and then we're again adjusting to this environment where people are very cautious. They do have health concerns and COVID concerns, and now we're entering into a space that really we can't control. So we do have to follow those remarks, and we do have to leave a business card. So that is our unfortunately, that's the way we have to play at this time.
I do have a quick note about the 41A.
Yes.
Yeah, so the main reason to use the BCR one is it's better than the standard MLS one. because it's a bilateral contract, like a listing agreement. So it has to be terminated by both parties in writing, rather than the 41A and the MLS is a unilateral contract that either party can terminate via an email. So I had a situation where, it's a long story, but I was actually able to still get a referral check from my buyer that we no longer wanted to work together. So save me $6,000. But if it was just a standard 41A, wouldn't have been able to do that.
Right. So that's a great, I forgot about that one that happened to you, Tristan. That's great. That you
Closed
brought
on
that up.
Friday. We should be getting paid from it today or tomorrow.
Nice.
Yeah.
So that was a quick, easy money just by using, that's a $6,000 contract then, really, you know?
Pretty much. Yeah.
Pretty cool. Awesome. Thanks for sharing. Appreciate your insight on that. And yes, we are going to be looking at modifying 41A, our 41A, just to be in alignment with the new forms that are coming out. So you'll probably see some revisions on that agreement. So continue to use it through October, but November, December, you can be assured we'll probably need an update in terms of that to make sure it works well with the documents we're going to see. Okay, fantastic. Shannon, anything else?
No, I think that covers it.
Okay, awesome. Have a great week, you guys. Enjoy. There is a lot more activity this week, so that's good news for buyers and for sellers. Get the word out. The water is warm. There are some fantastic deals for buyers out there right now. I'm seeing a lot of sellers who are getting a little antsy, and that's the time to pick them up. So get your buyers out there. The rates are still under 6, and it's a great time to get them out there and start securing some of these deals. And then refinance maybe next year. You know, we don't know what's going to happen next year, but it's still a very, very good time to buy as well as to sell. So have a great week, and we'll talk to you guys soon.